Welcome to Salam Immigration. I'm Sheikh Asif Salam. I want to share with you some information and knowledge about statelessness under the immigration rules. Statelessness means someone doesn't have any nationality or he is unable to assert his nationality from wherever he has come, like his country of origin would not accept him as a citizen of such country. Like we have a recent example of the Rohingyas from Burma. Burma says they are not our nationals. They are pushed back. They are rather forced to flee the country. A lot of them, millions of them, have fled mostly to Bangladesh, and Bangladesh says you are not our nationals. They do speak Bengali or whatever, but no country is accepting them. Some of them have gone to India. India has also, say, West Bengal there. They also don't accept them as their nationals. So they don't have any nationality, so they are considered as stateless. Similarly, a lot of other people would not have luck with getting passports or acknowledged by their own countries or the embassies of their countries to say that yes, they are our nationals. So in such cases, they become stateless. But if someone has been accepted as a refugee from that country to any other country, they flee their country and they go to somewhere else, they reach UK or any other country and they accept them as refugees, then they are not by definition stateless because they have been given the status by some country allowed to live there. So the separate rules apply for stateless people and separate for refugees. Now, statelessness rules they stem from Article 1, Sub-Article 1 of the 1954 UN Convention, which defines statelessness. And the immigration rules, they also provide the rules for accepting someone as a stateless person. And if someone is stateless, then he gets status here. Some of the stateless persons would still not get status because of their very serious criminality like war crimes or crimes against humanity, crimes against peace, or very serious non political crimes. So, if someone has been guilty contrary to the UN principles, then they may not still get any status or any relief, regardless whether they are stateless or not. For the purpose of proving that they are stateless, the first thing is that they are in the UK. I'm talking about the UK regulations or the UK rules to stateless persons, not generally here. So if someone is already in the UK and then he claims that he is stateless, then he has to prove that he is stateless. That doesn't simply mean that they claim that I am from such and such country or I am from no country at all. Obviously, he would have come from some country. So he would have to prove that he has tried to assert his nationality. He has taken steps to get a passport from the embassy of that country in the UK, and they don't recognize him as a national of their state and are not willing at all to give him any passport or document. So he must have sought the nationality and would have failed. Otherwise, it's not proven that he is stateless. So he has to provide evidence to demonstrate that he is stateless. If someone is born in the UK and his parents are not British, then he has the nationality of the parents. But if the parents don't have the uh, status from that country, they are themselves stateless, so the child also has the same problem. Or even if they have their nationality sorted out, but their country is not accepting them as their citizens, or that they've tried to register their birth with the relevant authorities of that country, like they go to the embassy to register the birth, and the embassy of their country of origin is not accepting them as their nationals and they are not accepting the registration of birth, then also, if they can prove so, they will become stateless. They can then prove that they are stateless. A recent example of this is about the Indians. In India, the rule is that if someone who is born outside India, he should register himself within a certain time at the embassy of India in that country. And if he does not do so, then he loses his right to get that birth registered with the embassy. And if he loses that right, then he may not get Indian nationality. So there has been a recent case in which the upper tribunal has held that Indian children who have not been registered with the embassy of their country in the UK, Indian embassy in the UK, and they are now 5 years old and they have had no status, or they have had no nationality from India or no passport, then they are to be considered as stateless and they should be granted British nationality. Uh, the Home Office is not very happy with the decision, obviously. So the decision is with the Court of Appeal. Let's see what the Court of Appeal would say. But a lot of Indians have tried to make use of it or abuse this thing by not registering their children with the Indian embassy in the UK and wait for them to be 5 years old so that they can then apply for the British nationality of the child, and on that basis the parents who may not have any status here, who would be overstayers or illegal here, they would also ask for stay on the basis that they are parents of a British national child. Now, if someone has been granted status due to them being stateless, then their dependents would also get the same status uh, if they fulfill the requirements. The requirements are not anything difficult. When someone gets this status, they get a 5 years leave, and if after 5 years their condition is still the same, they still remain stateless, their country doesn't still acknowledge them, does not acknowledge them, then they will get indefinite leave to remain, and after that they will get nationality ultimately. So that's all about statelessness in, in a summary form. If you need more details, do let us know or consult your nearest immigration solicitors and they will be able to help. Thank you very much.